Good evening, listeners. Uh, I'm happy to be talking to you today about a subject which is very important for all of us and which concerns an aspect of the law which I have been studying, and that is what have come to be known as anti-conversion laws over the years. Let me tell you a little bit about the background to these laws. Such anti-conversion laws have existed since time immemorial, even while India was governed by princely states. Most of these princely states were the principalities of Hindu kings and queens, and their subjects were also predominantly Hindu. But given that Hinduism was the religion of the rulers, they did enact laws which prevented their subjects from converting to a different religion. The logic of these anti-conversion laws, which existed before the Constitution came into force, was that these states were not secular states. Let's come to a time when India became a democratic secular republic on the 26th of January 1950. We all know that our Constitution is a sovereign, secular, democratic republic. We also know that this Constitution contains the guarantee of freedom of conscience and the right freely to profess, practice, and propagate any religion in Article 25 of the Constitution of India. So there is a logic between having the right to freedom of conscience and religion and the guarantee of secularism. Because in theory, all our religions are entitled to equal respect by the state and by the Constitution. Also, the state itself has no religion of its own. That is why we call it a secular state. So whether you're Hindu, Muslim, Christian, Parsi, or Jew, or any other religion, or an atheist, you are entitled to equal protection of laws and equality before law. You are quite simply a citizen. Now, if we look at these so-called anti-conversion laws in the context of secularism, I'm afraid we'll find them all wanting. On the face of it, they have the most innocuous title. They are known as freedom of religion laws, and they're often passed off as laws which are intended to guarantee the freedom to all of us to belong to any religion. But before I talk to you about these laws, let me talk to you about how do we as human beings acquire a religion. The answer to that is very simple. We all appear to be born into a religion. We do not acquire it. It is not an act of volition. And this is for the reason that we inherit at birth the religion of our parents. Now, so if both my parents happen to be Hindu, well, I'm born a Hindu. If both my parents happen to be Christian, I'm born a Christian. A question that might arise in your mind is, what if one of my parents is a Christian and one is a Hindu? To which religion will I belong at birth? The answer to that question depends upon the manner in which parents bring up their children. So if they have brought up their children in the Hindu way, the child will be considered a Hindu. If they have brought up the children in a Christian way, and for example baptize the child will be considered a Christian. Now what happens? How can we shake off our religion? Therein lies the answer to the question, freedom of religion. each one of us, on attaining the age of maturity or the age of majority, has a right to adopt the religion of our choice. I use the word adopt rather than the word convert because when we make a choice of religion for the very first time in our lives, we are actually adopting a religion. We are not, quote unquote, converting. So let's work with this concept that we adopt a religion of our choice. It could be any religion. It is an act of conscience, and we are not accountable to anyone for this choice, precisely because it's an act of conscience. Which is why Article 25 actually uses the word freedom of conscience. Now, let's come back to these so-called anti-compulsion laws. What do they tell you? They've existed since 1967. Orissa, Madhya Pradesh, Chhattisgarh, Jharkhand, Himachal Pradesh, Gujarat, all have these laws in place. And these laws, ostensibly guaranteeing freedom of religion, are basically saying that no one can be unduly influenced to convert to another religion. Now, so far so good, because the word undue influence and the words fraud have a well-defined meaning. No one would support another person being misled or being wrongfully, against their will, converted to another religion. The problem, however, is that there is an unstated, unspoken agenda to these laws. And secondly, the minute you say that your decision to convert or adopt another religion will be scrutinized by an executive authority, you are bringing the state into the decision-making process. A magistrate or a court will look at the question whether you have been forced or you have been unduly influenced to convert. That is one major problem. But the real issue is the agenda of some of these laws is to prevent Hindus from opting out of Hinduism. And it's here that we need to understand the definition of who is a Hindu given in law. Some of our laws tell us that anyone who is not a Christian, not a Muslim, and not a Parsi is a Hindu. So it's like a residuary category, and all of us are supposed to be Hindu, except, as I said, Muslims, Christians, Parsis. So Adivasis are Hindus, scheduled caste people are Hindus, scheduled tribe people are Hindus. Now, therefore, it's a dominant community trying to prevent people from joining the religion of any community other than the dominant community, which is the basis of all these laws. Let me move on to the 1920s, where suddenly these laws became qualitatively different. When we come to the laws enacted in 2017, 2019, and 2020, there is an attempt to say that when a person adopts a new religion for the purpose of getting married, then that adoption is also bad in law. So, for example, in 2017, we had a law in Jharkhand which linked the issue of conversion with marriage. In 2018, we had a law in Himachal which did the same thing. And ultimately, in 2020 October, we had an ordinance from Madhya Pradesh and from Uttar Pradesh which explicitly says that if you convert for the purpose of getting married, then that conversion is bad in law. Let me now explain why this is wrong. Although in this country we do have a law known as the Special Marriages Act of 1955, which enables two people to marry while keeping their separate religions, we also have laws like Hindu law, Muslim law, Christian law, Parsi law, where two people belonging to the same religion can marry. Now, the decision which two people make whether to marry under the Special Marriages Act or the Hindu, Christian or Parsi Marriages Act is a very personal decision. And if two people decide to marry under Islamic law and one is a Hindu and the other is a Muslim, the Hindu will have to convert to Islam. Similarly, if two people wish to marry under Hindu law and one is a Muslim and one is a Hindu, the other person will also have to convert to Hindu law, and all such marriages are legal and valid marriages. In other words, adoption of a different religion for the purpose of getting married is a very legitimate form of getting married, because in this country we have recognized parallel legal systems that we call personal laws. And therefore, these laws, in my opinion, which prevent conversion for the purpose of getting married, are all unconstitutional laws. These laws have been challenged in the Supreme Court, in the High Court of Allahabad, and we have to await a decision from our courts to see how they will handle these issues. Let me conclude by saying the issues that these laws raise have a very personal character to them. They are linked to a decision which is very private, which is very personal, and into which no person has a right to interfere. I do not wish to be accountable to any organ of the state for a decision which I take to adopt a different religion or to marry a person of a different religion or the manner in which I get married. I do not wish to be told that I have to marry only under the Special Marriages Act and no other law. And this is what these laws are telling us. Finally, the ultimate irony is that it's mainly Hindu men, as the data shows, who convert to Islam for the purpose of getting rid of an inconvenient Hindu marriage, or for the purpose of acquiring more than one wife. This phenomenon is documented in a judgment of the Supreme Court known as the Sarlamurpur case. We do not support these type of conversions. They are not based on the choice of a religion, but they are based on a cynical view of their own personal lives, their inability to put an end to a marriage which they do not wish to be in through lawful means, and they use unlawful means to get out of a difficult marriage. So I think we need to, in conclusion, distinguish between decisions which are taken voluntarily for a bona fide purpose and decisions which are taken for these cynical reasons. Thank you. I'd be happy to answer any questions you have.